The 5 characteristics of enforceable contracts consideration. Both parties must give and receive consideration for a contract to be valid. If Jack signs a contract with Paula, agreeing to buy her residence for a specified dollar amount, Paula's consideration is the residential property, which she promises to sell to Jack. Jack's consideration is the money that he will provide in exchange for the house. In basic terms, the offeree, that is the person being offered something, must give something back to the offerer in return for the promise. That which is of value to one party exchanged for something of value by the other party is a consideration. In the initial stages of a transaction, the promises provided by each party represent consideration. For a contract to be valid, it must specify consideration for both parties. In the example listed above, the agreement involves a promise by the purchaser to pay a certain amount of money to the seller, with a promise by the seller to convey title to the property after the price has been paid. This is a valid contract because both parties will give and receive consideration. If Paula provided the house to Jack without requiring consideration, there would be no contract. Instead, Paula's house would have simply been a gift to Jack. A court would not be able to help Paula out unless the contract specified Jack's consideration. Note: consideration must be of real value to the other party. It does not have to be in the form of money, rather. It can take the form of goods or services that have monetary value. The receiver must interpret the offering as valuable. For example, an offeree could exchange services, such as business consulting, in exchange for title to an offerer's real property. Capacity. The word capacity has several definitions which depend on use. However, in contract law, capacity refers to an individual's competence to perform. It also pertains to legal right to perform. Competence to perform. If a person has been declared incompetent by a governing body, he or she cannot legally negotiate or sign a real estate contract. If, for instance, a mentally incapable person was awarded ownership of property and later signed a contract to sell his or her property, the contract would be void. The same is said for a person who is temporarily declared incompetent. Reasons for temporary incompetence may include temporary head or brain injury, or it could be on behalf of one who is under the influence of prescribed drugs while involved in the transaction process. As a general rule, incompetence is defined as someone who is entire without understanding. After a person has been declared incompetent, mental disability, retardation, senility, any contract entered into is void. If the person entered into a contract before the declaration, but while of an unsound mind, a court-appointed guardian can ask the court to terminate the contract. In some cases, if a person can prove that he or she was involuntarily intoxicated while in the contracting process, a contract can be classified as avoidable. Legal right to perform. For a contract to be considered sustainable, the parties must have the legal capacity to contract. For instance, a person must be the age of majority, 18 years old in most states, and have the intellectual competence and maturity to act on his or her behalf. In most states, minors do not have the capacity to perform acts, such as contracting to purchase property on their own. This means that if a minor signs a real estate contract, the contract cannot be enforced against the minor. However, a minor that has been legally emancipated may sign and be liable for enforcement of a contract. Emancipate means to free one from restraint, control, or the power of another, such as parents or legal guardians. In many states, when a minor marries, he or she becomes legally emancipated. In this situation, if the married minor signed a real estate contract, he or she may be obligated to fulfill the terms identified in the contract. Note: depending on state law, a minor or a legally incompetent person may be legally managed by a parent or a court-appointed guardian. Legal intent. For an individual to be obligated by contract, he or she must intend to establish legally enforceable duty. In other words, the purpose or intent of the contract must be legal. Suppose a broker named Jones uses his knowledge of contract law to help ensure that the buyer of his property understands the terms and obligation he must meet to qualify to purchase his residence. His ultimate goal is to ensure his buyer follows through with his contracted responsibilities. Jones's contract development process included ensuring that the contract is mutually agreed upon, that it was made in writing, that both parties gave and received consideration, and that they have the capacity to enter into a contract. As part of his consideration clause, Jones stipulated a second purpose behind the contract, that he would receive 20% of any proceeds generated from drugs that were manufactured in the home for 5 years after the sale. If Jones's buyer breached the contract by not meeting the contract terms, and Jones decided to sue, a court may uphold the sale portion of the contract, the first purpose of the agreement, but the proceeds from drug manufacturing would be void, the second purpose of the contract, because it is against the law. In this way, courts may choose to discard unlawful contract objectives and still support the legitimate ones. If, however, a contract has a single intent and this intent is unlawful, the complete contract is void. For example, Jerry, a certified building inspector, is asked by his friend to inspect the ventilation and electrical systems of a cabin she is in a hurry to complete. Jerry notes discrepancies in his friend's work, but because his friend will not have time to make the otherwise required modifications before the snow begins to fall, he signs off on her work as acceptable. Real property contracts. About the author, Michelle Lind, CEO of Arizona Realtors, R., is also an attorney, State Bar of Arizona Board Certified Real Estate Specialist, and the author of Arizona Real Estate, A Professional's Guide to Law and Practice. Please note that this article is of a general nature and may not be up to date or revised for accuracy, as statutory or case law changes following the date of first publication. Further, this article reflects only the opinion of the author, is not intended as definitive legal advice, and you should not act upon it without seeking independent legal counsel. Contracts are the basis of buying and selling real estate. A contract is a legal document that affects the buyer, seller, brokers, and every other person involved in a real estate transaction. The contract in a real estate transaction can prevent problems or cause disputes. If the following basic contract law principles are applied, each transaction will proceed more smoothly, with fewer disputes and less liability for the parties and brokers involved. General contract requirements. For a valid contract to exist, there must be an offer, acceptance, consideration, and sufficient specificity so that the obligations involved can be ascertained. K-Line Builders, Inc. v. First Federal Savings and Loan Association, 139 Arsnew 209, 677 P2D 1317, Appian 1983, discussing minimum contract requirements in a case involving a financing contract between a builder and a savings and loan. However, real property contracts must meet certain other requirements and usually contain numerous other important provisions relating to the transaction. Offer and offer is an expression of a willingness to enter into an agreement, so made as to justify another person to believe that assent to the offer will conclude it. K-Line Builders, Inc. 139 Arizar 209, 677 P2D 1317, App 1983. In other words, an offer creates a power of acceptance, permitting the offeree to transform the offer into a contract. When an offer or counteroffer is not supported by independent consideration, it may be withdrawn at any time prior to its acceptance. Bevins v. Dixon Electronic Corp. 16 Aris Appy 105 491 P2D 494 1971. Patton v. Paradise Hills Shopping Center Inquiche 4 Aris. Apt 11 18 417 P2D 382 1967. Butler v. Wearley 5 Aris. Apt 228 425 P2D 130 1967. Any statement clearly implying an unwillingness to enter into a contract according to the terms of the offer, communicated to the offeree prior to unequivocal and unconditional acceptance of the offer, is sufficient to withdraw an offer and prevent contract formation. Although formal notice that the offer is withdrawn is not necessary, written confirmation is advisable. See Butler, 5 Aris, App at 232 425 P2D 130. Further, a written offer can be verbally withdrawn, although again, the verbal withdrawal should be followed by a written confirmation. See Executive Towers v. Leonard, 7 Arizers Apart 331, 439 P2D 303, 1968. An offer that has been accepted cannot be withdrawn. Richards v. Simpson, 111 Arizy, 415, 531 P2D 538, 1975. In the Richards case, the court held that the actions of the prospective buyer in subsequently signing the offer after the offer had been withdrawn did not constitute acceptance of the offer while the offer was still open and a contract was not formed. See also Butler v. Warely, 5 Arizabah, Appy, 228, 425 P2D 130, 1967. Acceptance. Acceptance is a manifestation of assent to terms of an offer in the manner invited or required by an offer. K-Line Builders, Inc., 139 Ayers 2109, 677 P2D 1317, Apper 1983. Acceptance of an offer must be conveyed to be effective. Ad Empire Machinery v. Litton Business, Telar Systems, 115 Ayers Dars, 568, 573, 566 P2D 1044, 1977. Silence does not ordinarily establish acceptance. Farnsworth on Contracts, Par 314 P. 231, 1991, citing Restatement, 2nd of Contracts, Par 56. It is essential to an acceptance by promise either that the offeree exercise reasonable diligence to notify the offerer of acceptance or that the offerer receives the acceptance reasonably. If the offer does not specify the manner for acceptance, any reasonable manner of acceptance will be permitted. If the offer contains no time for acceptance, the seller must accept the offer within a reasonable time. However, if the offer specifies the time and manner for acceptance, that provision will control. Therefore, when drafting an offer, it should specify the manner and time for acceptance. For example, the AAR resale contract at Section 8P specifies terms of acceptance. This offer will become a binding contract when acceptance is signed by seller and a signed copy delivered in person, by mail, facsimile, or electronically, and received by broker named in Section 8R by Chuisburgi at 2 a.m. p.m. Mountain Standard Time. Buyer may withdraw this offer at any time prior to receipt of seller's signed acceptance. If no signed acceptance is received by this date and time, this offer shall be deemed withdrawn, and the buyer's earnest money shall be returned. Acceptance of an offer must be in the exact terms as the offer, and any attempt to accept in terms materially different from the original offer constitutes a counteroffer, which rejects the offer. A counteroffer can become the basis of a contract only if it is accepted by the person who made the original offer. Malkoff v. Koye, 14 Arizambio, App 524, 526, 484, P2D 1053, 1055, 1971. Clark vs. Campagna, Ganadera de Cananea, S.A., 94 hours, 391, 385, P2D 691, 1963. To create mutual consent and therefore a contract, acceptance of the offer must be unequivocal. Richards v. Simpson, 111 Arizona 415, 531, P2, 538, 1975. United Caldas Bank v. Prudential in Zarcao, 140 Arza 238, 681, P2, 390, 1983. Again, once a counteroffer is made, the original offer has been rejected and cannot be accepted. Consideration. Although consideration is necessary to a valid contract, consideration is easily demonstrated. Consideration need not be money, but may involve a promise for a promise. Carroll v. Lee, 148 Arizona 10, 13, 712, P2D 923, 1986. Consideration may also be a benefit to a promiser or a detriment to a promisee. Consideration may be entirely without benefit if there is a detriment to the promisee. Grant v. White, 103 Arizar, 257, 439 P2D 828, 1968, citing Kavanaugh v. Kelly, 80 Arizar, 361, 297 P2D 1102. Sellers agreed to accept a smaller down payment in return for the broker's agreement to make part of commission contingent on buyer's future performance. By Arizona statute, every contract in writing imports a consideration. ARS, paragraph 44, 121. However, many contracts still set forth the consideration by the familiar term for $10 and other valuable consideration, or by requiring earnest money.